Tom Abbott with Parham & Associates, and today I'm going to talk to you about self-defense laws in Texas. Generally, self-defense is the right of any individual to defend themselves from any sort of unlawful use of force up to and including deadly force. Now, the thing that you have to keep in mind with self-defense in Texas is that reasonableness is the standard. Under the statute, you have a right to defend yourself from, in any manner, with a reasonable use of force. For instance, if someone is coming at you, maybe they are brandishing a weapon, and you are reasonably afraid of that, you have the right to defend yourself, and you can go all the way up to shooting them with a gun. Even if they, are only brandishing a knife or perhaps maybe a metal bar or a bat, something of that to that effect. Even if they're coming at you with just their fists, if you reasonably believe that your life is in danger, you have the right to defend yourself accordingly. Now, I want to go over a couple of the little caveats to this. And the first thing I have to point out is that in Texas, unlike many other states, there is no duty to retreat. You are allowed to stand your ground and defend yourself. Some other states require that you have to at least try and retreat, and if retreat is, you're unable to complete that, then you can use self-defense. But in Texas, someone's running at you, you don't have to turn and run yourself, you just pull out the gun and defend yourself. There are a couple of caveats to that. First of all, you cannot have initiated the altercation. If you walk up to a person and punch him in the nose, and he punches you back, and any action you take thereafter will not be considered self-defense. You started this fight. And so therefore, you don't get to claim that you're defending yourself. The other caveat is that you cannot be engaged in illegal activity at the time. This is meant to cover, say, an accused breaks into another person's home. They're thinking that no one's home. They're just going to steal the TV or some jewelry, something like that. Homeowner comes around the corner with the gun. The burglar, the person that entered illegally, has no right of self-defense at that point because they've broken a law. Point in fact, the person that's in the home is the one that's going to have that right of self-defense. Additionally, this can also cause problems in terms of cases where maybe two individuals are involved in a narcotics transaction. Something goes wrong. One party pulls a gun. The other party pulls a gun and fires first. Because they were both involved in an illegal activity, neither one of them would have the right of self-defense. The other issue that you're going to have to deal with is that it's going to need to appear to be reasonable. If, for instance, if someone is just threatening you verbally, but you have no reasonable belief that they are about to act on those threats, you probably don't have a right of self-defense at that point. It needs to be very immediate, and it needs to be very reasonable under the circumstances. So if someone comes in and says, they're unarmed, and they say, well, I'm going to kill you next Tuesday, until they show up on Tuesday with a weapon or, looking like they're going to actually act out that threat, you're not going to have that right of self-defense. But, again, you've got to keep in mind the reasonableness. It's going to depend on what their current actions are. For instance, the famous scene in Star Wars where Han Solo's at the cantina and the green alien comes in and is telling him that he's going to take him back to Jabba and, he's going to be killed. What makes Han Solo's use of self-defense reasonable in that situation is that this green alien does have a weapon that's pointed at him. So it looks like he's in the process of acting out his threats, which then makes Han's belief reasonable that he needs to defend himself. once this issue is raised at trial, it changes the nature of what the state has to prove to some extent. First of all, the state still has to prove beyond a reasonable doubt that you committed the assaultive offense, whether that's an aggravated assault, a regular assault, or even a murder, potentially. They still have to prove that beyond a reasonable doubt. If the jury believes that that offense and all of its elements have been proven beyond a reasonable doubt, then they have to consider the evidence of self-defense. And if they find that your belief in the need to defend yourself was reasonable, then they are to enter a verdict of not guilty, even though they've already found you essentially guilty of the assaultive offense. This does change the state's position to some extent. It is not a true shifting of the burden. Obviously, the state will want to put on some evidence to refute the reasonableness of that self-defense claim, but it is still a defendant's claim, and so therefore the defendant is the one that has to prove it. One difference, though, is they do not have to prove it beyond a reasonable doubt. They have to raise some evidence, and they have to, show more likely than not that that claim is a valid claim. In terms of getting this evidence in, it can come from any source. It does not have to come from the defendant himself. If he made any statements to the police that he was acting in self-defense, he or she was acting in self-defense, then those statements would be evidence of self-defense. So you don't necessarily have to waive your Fifth Amendment right in order to get this in. If there is any evidence of it at all from any source, the trial court is required to give that instruction to the jury. And then they will consider the evidence. They have to find you guilty. If they can't get to that part, they never get to the self-defense argument. They just simply find you not guilty. But if they do get to guilty, then they consider the reasonableness of your actions in that self-defense.